Now we come to the second element to form a valid binding contract, that is acceptance. Acceptance in bahasa means penerimaan, where the offeree to whom the proposal is made signifies his assent, the offer is said to be accepted. And then the rule is once there is acceptance, there is a contract. So this is the meaning of acceptance. The person whom being addressed with the offer agreed or give his consent, signifying that he wants to accept the offer made by the offeror, there is an acceptance. Once there is acceptance, there is a contract. This is the example what is an acceptance. For example, let's say Zaid offer to sell his car to Adam for 30,000. Adam is the offeree. So when Adam signifies to Zaid that he agreed or give his consent to buy the car for that 30,000, Adam here is making an acceptance. So Adam is called as the offeree or promisee or the acceptor. What are the valid conditions of a valid acceptance? In order to make the contract becomes binding, the acceptance must be valid. So what are the conditions to be fulfilled? So the first condition is the acceptance must be absolute and unqualified. This is by virtue of Section 7A of the Contracts Act 1950. So what is the meaning of absolute and unqualified? It means the acceptance must be made without any condition or qualification, meaning without any added condition to the acceptance or any qualification. Qualification here means modification. So here it means your acceptance must be made exactly on the same term of the offer without any modification. So if you accept exactly the same with the offer, your acceptance is valid. Any modification, if you modify the term of the offer in your acceptance, it means you have made a counter offer. What is the effect of a counter offer? Once you make a counter offer, there is a rejection of the original offer. So there is no valid acceptance, because when we go back to the condition saying that your acceptance must be absolute and unqualified. So if you modify the term of the offer, you are not making a valid acceptance. You may refer to the case of height versus range. This is the example of a counter offer. How a counter offer may happen. Let's say Zaid offered to sell his car for 30,000 to Adam. And then Adam made the acceptance. He agreed to buy the car. But he modified the terms of the offer, saying that he agreed to buy the car for only 25,000. So here it means Adam has modified the terms of the original offer. The original offer is for 30,000. But he accepted for only 25,000. So here it means that Adam has modified the terms of the offer. So in that case, there is no valid acceptance because Adam has made a counter offer. Exception. Even though there is a counter offer, sometimes contract may happen if the counter offer was accepted by the offeror. For example, in the same illustration also, when Zaid offered to sell his car for 30,000 to Adam, and then Adam agreed to buy the car but for 25,000. So there is a counter offer. But if Zaid accepts the counter offer made by Adam, there is a valid acceptance by Adam, and therefore the contract is binding. The second exception is a request for further information, that is inquiry about the offer itself, that is not a counter offer. Meaning, if the offeree asks something about the offer, that question or that inquiry cannot be regarded as a counter offer. For example, let's say in this situation, when Adam inquired from Zaid, asking Zaid whether Zaid agreed or not to sell the car to him for 25,000. So this is only a matter of inquiry. Adam seek for the agreement of Zaid, whether he agreed or not to sell the car to him for 25,000. So this is not a counter offer. And in this situation, the offer is still open for Adam to make an acceptance. Second condition of a valid acceptance is the acceptance must be communicated in some usual and reasonable manner. This is by virtue of section 7b. What is the meaning of usual and reasonable manner? These are the illustrations about how an acceptance can be made. It must be communicated by any means of usual or reasonable communication. So the offeree, if he wants to accept, he must accept either by WhatsApp or Telegram or by a phone call or fax and emails. So these are common and usual for the offeree to make the acceptance. Exception by virtue of section 7b, which further provides that unless the proposal prescribes the manner in which it is to be accepted. So, in this situation, if the offeror prescribes or stipulates or put a condition on the manner how to accept, the rule is the offeree must fulfill the manner as prescribed by the offeror, then only the acceptance is valid. Otherwise, the acceptance is not valid. For example, you can read the case of Malaysian versus Henshaw. So this is an illustration where the offeror stipulate or prescribe the manner of acceptance. Let's say Zaid, who has a piece of land, he wants to sell his land to Adam, and he offered to sell the land for 150,000. But in his offer, Zaid mentioned that in order to accept this offer, Adam must first go to the land office, and second, he has to fill in certain form and he has to pay certain fees. So this is the prescribed manner given by Zaid. So in this situation, Adam here, in order to make the acceptance valid and binding, he must go to the land office and fill in the form and pay the fees required. So this manner must be fulfilled by Adam. Then only there is a valid acceptance. What about if Adam did not fulfill the manner of acceptance? Let's say Adam, he didn't fulfill the manner, he didn't go to the land office, he didn't do everything as required, but what he did, he just go and see Zaid immediately and pay booking fee for the land for 20,000. So meaning here, Adam did not fulfill the manner of acceptance. What he did is not according to the manner. So in this situation, there is no valid acceptance and it is not binding on Zaid. In conclusion, there are two valid conditions for acceptance. First, the acceptance must be absolute and unqualified. It must be made exactly the same with the term of the offer. Otherwise, the acceptance is not valid. Second condition is the acceptance must be made in usual and reasonable manner. Unless the offeror prescribe the manner of the acceptance, in that case, the offeree must fulfill the mode of acceptance.